Hi, this is Kelsey Fukowski for AP Gov Review, and in Unit 4, Part 1, we'll be looking at the federal court system as part of our endeavor to study more closely the judicial branch. So let's take a little bit of an overview of the judicial branch here, and of course its main objective is to interpret the law. It does differ from other countries in the respect that it is responsible for making policy at times, as we most clearly can see with the Supreme Court. And contrary to popular belief, most cases are indeed tried at the state level and not actually in the federal court system. That is very important to realize, that most cases are heard at the state level and not at the federal level. And oftentimes the judicial courts are known as the watchdog of the other two branches. Probably a good watchdog example would be if the Supreme Court declares a law of Congress to be unconstitutional. You are basically watching or checking Congress to make sure that they are operating within the bounds of the Constitution. You may wonder, how does the Supreme Court or the judicial branch check the president? Well, should the president, for example, issue an executive order that might be out of bounds of the Constitution, that's of course where the Supreme Court, if they were to get to hear the case, they would rule it unconstitutional. So those are some checks, and hence it has that watchdog function. So ultimately, in the Constitution, where does it get its structure? It actually comes from Article 3 of the U.S. Constitution, and very, very little is said about its structure, almost as if it's an afterthought, like, oh, we'll figure it out, whatever happens, happens. So in Section 1 that you see here, the Supreme Court is mentioned that Congress is given the responsibility to set up all other federal courts, and justices are going to serve for life in good behavior. What does good behavior mean? I mean, that is a little bit ambiguous, but nevertheless, has to be good behavior and receive compensation. One of the reasons why judges are going to serve for life is so that they are sort of free from political influence. We'll see in other videos on the Supreme Court here that justices by no means are immune from politics or the media or the news, but nevertheless, that was indeed the intention, that they would not be swayed to lean one way or another towards the politician who had appointed that Supreme Court justice or that federal judge. In Section 2, jurisdiction of federal courts is going to be defined, and we'll be getting into that. Specifically, appellate jurisdiction is going to be given to the Supreme Court, where if you have a case that one wants to appeal to a higher court, that is where the Supreme Court is going to come in. So ultimately, where you're going to file an appeal, hence the appellate, if you can make out the word appeal more or less in here, that's where the Supreme Court is going to oversee the lower courts. And then in Section 3, it's going to focus on treasonous activities, which are basically irrelevant here for the AP Gov test. Now, the real power of the branch does not come anywhere here. You do not see anything saying about the Supreme Court really have any muscles or really any power. Where it really comes about is in a very famous landmark Supreme Court case that you should be familiar with from U.S. 1 history, Marbury v. Madison in 1803. Chief Justice John Marshall, who is basically the father of the judicial branch, establishes the power of judicial review. And that is indeed the power to rule on the constitutionality of laws. That basically is meaning that, hey, if a law is unconstitutional, the Supreme Court can overturn it. So really where he gets these powers is going to be from Article 3, and even though you don't see really anything mentioned about it here in Section 1, 2, or 3, it's going to nevertheless be an implied power. And again, this is a power not really originally given to the Supreme Court, but this is significantly going to bolster the power of the Supreme Court that we know of today. Of course, the original power was to find and apply existing law and settle disputes, but here you have John Marshall basically giving the Supreme Court judicial review, and that is very, very important to know. You'll definitely see that in some form or another judicial review. But again, that is the power to rule on the constitutionality of a law. So if they are overturning a law, then that is the power of judicial review. All right, moving on. In Federalist Paper number 78, Hamilton is talking about the judicial branch actually being the weakest branch. And again, that can be debatable today as well, but his real argument here was that the Supreme Court does not have the power of the sword or the purse, meaning it does not have the power to tax, which is of course the power of Congress. It does not have the sword either for implementation purposes, which of course the sword being the executive branch. So it is very much dependent on the other branches. And in many ways, this prevents the Supreme Court from making an outlandish ruling. Because if it's so outlandish, you always have the fear of the Supreme Court that the ruling is not going to be implemented. Are you going to see a Supreme Court justice come out there and make sure that their ruling is enforced? No, you're never going to see that. So as a result, you see the Supreme Court constantly making sure that they're sort of operating within the bounds of public opinion, which is going to be important. He's going to also advocate for tenure for life. Again, this is during the ratification process of the U.S. Constitution, to make them the least political branch. And in many ways, they might be the least political branch of the three, but they're still heavily involved. And this is still an essay cited by the most justices today as an FYI. Let's move on into part 2. So looking at the court system here, we have a dual court system, meaning that you have a federal court system and then you have your state court system. So every state has its own court, and then you also have one at the federal level. So a federal case is, what distinguishes it from a state case? Well, a federal case is one under the Constitution, the law of the U.S., or treaties. These are what you call federal questions. So if you are suing to say that the death penalty is unconstitutional based on the Eighth Amendment, well, that is indeed a federal question because that's dealing with the U.S. Constitution. Or let's say a person from New Jersey is, suing somebody from Virginia, or if it's, one of those matters, if it's out of more than one state, this is what you would call a diversity case, and indeed you'd have a federal court stepping in. Most are going to start in district courts with respect to federal cases. Now, state cases, this is where if you commit murder, you commit a crime of shoplifting, you're going to be tried in a state or local court. Again, most are never going to reach the federal court system. And again, remember, only constitutional questions can be appealed to the federal court and the Supreme Court. So again, it has to be one involving the U.S. Constitution, and that ultimately would allow your case to proceed outside the state. Also, with respect to both courts, there's something called dual sovereignty, where the state and federal authorities may prosecute the same person for the same crime or conduct under both state and federal law. So, for example, if somebody were to kill a civil rights leader, you would certainly have the state crime of murder, but then you would also have civil rights offenses, which would be illegal under federal law. So you can actually go after the same person. That has actually happened. Cases that go through the state courts can also be appealed to the U.S. Supreme Court, again, if they are involving a constitutional question, such as the death penalty violating the Eighth Amendment, as some states still do retain the death penalty today. Most cases, again, are very straightforward application of the law and are not going to pertain to policy making. So that is important to note. So when we look at the federal model here, you have district courts where you have original jurisdiction where cases are being heard. And then you have the courts of appeal. So if you're going to appeal the district court decision, it goes to the courts of appeal. And these are regional courts. And then after courts of appeal, you can appeal it one more time. And that is, of course, the Supreme Court, the highest court. And it really has the last say of the entire court system. No court is above the Supreme Court, hence the word supreme. So when we look at the structure of the federal judicial system, again, notice the Supreme Court is on top. You have your U.S. Courts of Appeal at the districts, federal level as well, federal administrative agencies. And then you also have what are called specialized U.S. courts. Those are dealing with something very specialized, such as taxes or bankruptcy. You also have high state courts. This is in the state level. So typically you have your local courts, you have your state trial courts. Most states have appeals, and then you have every state having its own state Supreme Court. And then again, after the state Supreme Court, it can only appeal to the U.S. Supreme Court should it wish to. So, the Supreme Court, only court required by the Constitution. Congress has established other federal courts through the Judiciary Act of 1789. And Congress is going to create two types of lower courts. Constitutional, as we saw with the district courts and courts of appeal, again dealing with constitutional questions such as does the death penalty violate the Eighth Amendment? And then you also have your legislative courts, as I was showing you in the past slide, with respect to tax courts or Court of Military Appeals, international trade. So you have those specialized courts as well. So again, with district courts, they have original jurisdiction, and that means that they are hearing the case first and they're determining the facts. They are indeed a trial court. So some of the things that they're going to deal with in terms of types of cases: federal crimes, supervised bankruptcy, naturalization, reviewing some federal agencies. So again, these are issues that district courts are going to hear. So when you look at their jurisdiction, right, so the cases by topic, constitution, treaties, all that good stuff, that is what you're going to hear in a federal court. Citizens of different states, governments of 2 or more of the 50 states. So if New York is suing New Jersey or New Jersey is suing New York over where the Statue of Liberty is, that's going to involve the federal court, because if it was going to be heard in the New Jersey State Supreme Court, obviously it could be a little bit biased there. Continuing on with the courts of appeal, they have appellate jurisdiction, and all that means is that they're going to review the legal issues in the case from the lower court. So right here we have the Court of Appeals. They'll be overseeing the district courts as well. They do not hold trials. They do not hear testimony. They're not concerned about facts at all. They are concerned about were procedures followed, and they also set precedents, meaning examples for the lower courts to follow. You do have 13 circuit courts, which are regional, and they are spread around the country. And you also have the U.S. Court of Appeals for the Federal Circuit, and as well as specialized cases. And again, as I want to reiterate, with the Court of Appeals, they are focused on errors of procedure, making sure that one's rights were followed, not the facts of the case. That's for the district courts. So again, here you're going to see the structure of the Federal Judicial Circuit Courts of Appeal. And oftentimes, they're not going to hear your case. It's very hard after you get past the district courts to hear it at the Court of Appeals level. And then after the Court of Appeals level, we of course know we have this U.S. Supreme Court, and that's even more difficult. All right, let's end with a review question here. What is the primary responsibility of the Federal District Court? And if you said choice D, you are correct, to serve as courts of original jurisdiction. Original jurisdiction and district courts go hand in hand in federal cases. All right, so very good. If you got that, kudos to you.